Welcome once again to my channel. In this tutorial session, we are basically going to discuss the law of defamation. What is entailed under the law of defamation? What do you need to prove when you are alleging defamation? What defense is available for the defendant? What are the remedies also available for the defendant? Basically, that is what we want to appreciate in this tutorial session. Once again, my name is Msiment Alex, and I implore you to subscribe to my channel, share with friends as we embrace the art of learning together. So today, let's appreciate defamation. What is defamation basically? Basically, defamation, this is a tort that this is the tort that protects the reputation of individuals, where any person who alleges that the tort of defamation has been committed against him, then that person must have a reputation that he or she needs to protect. That is basically what is under the tort of defamation. And the tort of defamation was critically and in depth discussed in the case of Rukoya Mkome, Francis Rukoya Mkome, and another versus the editor-in-chief of Buked newspaper, and two others. That case discusses what is defamation, from definition, from categories of defamation, up to remedies available for the plaintiff in case the claim succeeds. So it's a civil suit number 351 of 2007. That case will actually guide you on everything that is required in regard to the entire jurisprudence on that defamation, on the tort of defamation. The tort of defamation is basically divided into two categories, where we have libel and slander. Libel and slander, these are categories of defamation. Libel is basically where the publication, where the defamatory statements are published, are published in a permanent form. That is what it means. They are published in a permanent form. But under slander, they are not published in a permanent form. For example, if I'm to be brief now, like for slander, it's like when someone comes tells people, you see, a person X killed, just telling. That is not put in the permanent form. But under libel, then the defamatory statements must be in a permanent form. When we talk of permanent form, for example, we mean, let's say, the defamatory statements are published in the newspapers. Let's say the defamatory statements are recorded. Let's say the defamatory statements are written down with a pen or a pencil so that they can even be kept. That's what we mean by the difference between slander and libel. It is important that you take the difference between the two. Once you have the clear distinction, then we are good to go. To proceed and see, let me actually first bring out another distinction. You need to know that slander is not actionable per se, but libel is actionable per se. When we say actionable per se, we basically mean that you can sue without proving any damages. But for slander, you must prove that the defamatory statement, the alleged defamation, caused the damages to the plaintiff. And like when you're proving libel, under libel, it is presumed that that permanent thing that is defamatory caused damage. The law presumes that under libel, a damage must have been caused. That is very important that you need to appreciate right from the beginning. You will not understand defamation once you cannot separate the two. Defamation is divided into two: slander and libel. And the moment you know that slander is temporary, is not permanent. For example, they are like when you speak, you tell someone, that is not kept permanently. But a libel is like when you write on a paper and keep. That is very important that you need to appreciate. Like when you put in the newspapers and keep it for future reference, that becomes a libel because it is in permanent form. Like when you go to a television station and you speak something, that is libel because it can be retrieved from what was spoken actually on that day. It can be kept permanent. Once someone hears, he can go to the station and be like, we need this. It was said on this day and that day. That is permanent form. Once you get the distinction, then allow me proceed. You have to appreciate or read several books that discusses the tort of defamation, even any other kind of tort. The law of tort by Jorowitz and actually Jorowitz, that book discusses the tort of defamation. John Cook also discusses in the law of tort by John Cook. That book also discusses the entire law of tort. But specifically today we are interested in the tort of defamation. So let's now proceed and see what is needed, what should be proved for you to succeed in the claim of defamation. Number one, you need to know that the statements must be defamatory. The statements must be defamatory. Number two, the statements must have been directed to the plaintiff. Number three, the statements must have been published. There must have been publication. Without publication, there is a possibility that your claim of defamation will not succeed. That is very important. I said number one, the statements spoken must have been defamatory. Number two, the statements were published to a third party, to another person. Number three, the statements were directed, were the true reflection of the plaintiff. If a reasonable person hears or reads such statements, he will quickly know that they are referring to that person, to the plaintiff in question. That is what basically we are trying to mean here. Then you need to also prove that they caused damages. That is very important also. You need to prove that the statements caused damages. Just like I've mentioned these ingredients, they were also in the case of Francis Rukoya Mkome and another versus the editor-in-chief of Bookend, the newspaper. That case discusses them all. Get a soft copy of it, read that case. It's a very nice case on to that effect. If I may now take you somewhere far, we are basically looking, yes, you have a right to freedom of speech, freedom of information, but this tort says no, you cannot exercise that right beyond what is. We appreciated that when we were appreciating derogable rights, the freedom of speech. You can write what you want, you can speak what you want, but that in this regard, in the law of the defamation, you have a limit. You cannot speak anything that will destroy someone's reputation. That is what we are trying to appreciate. It is important that we move together and appreciate it. So, what do we understand when we say that the statement is defamatory? A statement being defamatory, you have to appreciate the case of Geoffrey Sejoba versus Reverend Patrick Rwabigonji. Sejoba versus Rwabigonji defines a defamatory statement as a statement which has a tendency, to injure the reputation of the plaintiff. Sejoba versus Rwabigonji defines a defamatory statement as a statement which has a tendency of injuring the reputation of the plaintiff or of the claimant. That is very important that you need to appreciate. Any statement that has the tendency, that can actually, if a reasonable person hears that statement, will actually believe that, will hate or will start fearing the plaintiff, that statement is defamatory. According to the jurisprudence in that case of, even according to the case of Francis Okoye, even this case of Sejoba, you speak a statement, but when a reasonable person hears that statement, he will actually start fearing. He will develop fear with respect to that person. That statement becomes defamatory. That is what we are trying to espouse now. It is important that we move together. You need to know that how do you interpret, how do you appreciate to know that the statement is actually defamatory or not? You must read the statement as the whole. When we are appreciating rules of interpretation, there is the rule that says you must read a statement as a whole, not in parts. For you to appreciate that a statement is actually defamatory, you must read the statement as a whole. And that was espoused by the Justice Sir Udo Udoma in the case of Adok. In the case of Adok, Nikon versus Tanganyika Standard Limited. Odok versus Tanganyika versus Tanganyika Standard Limited. That is when Sir Udo Udoma espoused that. He said that for you to appreciate that an article is defamatory, all statements are defamatory, then you must appreciate them by interpreting them as a whole. That is very, very important. You have to go and appreciate the jurisprudences in several cases that I'm trying to espouse here and there. Then let's now see where we say that there must be publication. Publication takes several circumstances. We are not only limited to publication in newspapers, but telling a third party also amounts to publication. If I tell my classmate that the lecturer did this, I'm trying to publish to a third party now. That also amounts to publication. But it will not be publication if a husband tells his wife. That becomes very different. That becomes very different, because if you appreciate the case of Odongokara versus Assos, Odongokara versus Assos, this case brings it out very well that publication to a wife does not amount to publication. Or telling a wife does not amount to, telling your spouse does not amount to publication, because once a person gets married, the two are now considered as one. That is what basically we mean when we say that publication to the spouse does not amount to publication. So you must ensure that the person that was told is not within that range. But any other third party, once that person receives information, then that amounts to publication. Then another circumstance that will not amount to publication is if I tell the very person, if I'm, let's say, if I'm telling John that John committed this, you have to appreciate that. If I'm telling John that he did this, then that does not amount to publication, because you can't communicate to yourself. You cannot communicate to yourself. You are like communicating to yourself. Or you cannot, like, there is no way you can bring it out very well, but you can. Publication will not be effective when you tell the very person that is alleging that he was defamed. In short, if the defendant tells the plaintiff, then that does not amount to publication. That is basically what it means. If a defendant tells the plaintiff that the plaintiff murdered, that does not amount to publication. Let me repeat these circumstances. If a wife tells the husband that James, now a different, now let's say a plaintiff, committed this, then this will not amount to publication, because a wife and a husband are presumed to be a single person. That is what it means. Then, if a defendant tells the plaintiff that the plaintiff did this, that does not amount to defamation. That is very important that we need to appreciate as we move on. I told you, with regard to spouses communicating between husband and wife, read the case of Odongokara versus Assos. That case will shed light on that. Then we have what we call that publication, rather that the statements were directed to the plaintiff. Here we bring in the issue of a reasonable person. If a reasonable person, any person who knows that person, reads that statement, will that person really believe that the statements referred to the plaintiff? That's what we are basically trying to mean. If we publish a statement that so and so is a member of robbers, that's what we are trying to bring out. If we say that so and so is a member of robbers, and a different person reads that statement, can he really believe? Can it come into his mind that actually this person is this one? They are actually referring to the plaintiff. That is what we are trying to mean here. So the statements, you must prove, when you go to court, you must prove that the statement actually referred to the plaintiff. That is very important, that you need to appreciate right from the beginning. Appreciate the case of Sejoba versus, I gave you the case of Sejoba versus Reverend Father. That case will guide you. Also appreciate the case of Francis Rukoya Mkome and another versus the editor-in-chief of Bukede newspapers. That case gives you whatever you want to know about the jurisprudence on defamation, because it discusses all the elements, all the ingredients. Then, as I earlier said, you must prove that the statement caused injuries. Once it did not cause injuries, then we are trying to avoid being biased or being awarding minimal damages. But if, of course, like we know, when you're suing under tort, of course, you be looking for damages. that is you must always have it in mind. So you must prove that it caused injuries to your reputation. I earlier told you that once you don't have reputation, you don't have what to prove. You don't have what you're alleging, because the law protects reputation, and if you don't have reputation, the law won't protect you. But at least you must have reputation. Okay. Then finally, you need to appreciate what are the available defenses, what are the available remedies for the parties who who bring a claim under the law of defamation. We shall have a video regarding remedies. We shall have a video regarding uh, defenses to defamation. That is very important. Otherwise, I want to thank you so much for watching. I want to thank you so much for your comments. I receive your comments, and they are encouraging, and I do whatever you want. And I want to again thank you for sharing with your friends. I still stick to the point of learning together, embracing the art of learning together. Thank you. Thank you so much.